The Société Fonderie case is about the place of supply of goods. Article 32 of the Principal VAT Directive is the basic provision for determining where goods are supplied for VAT purposes if they move from one place to another. Where goods are dispatched or transported by the supplier or by the customer or by a third person, the place of supply shall be deemed to be the place where the goods are located at the time when dispatch or transport of the goods to the customer begins. This is a rule which doesn't refer to or explain one of the important simplifications it involves. It doesn't matter where legal title to the goods actually passes. The contractual terms might say that the goods belong to the customer as soon as they leave the supplier's premises, or only when they arrive at the customer's premises, or somewhere in between. But you don't have to ask that question. All supplies involving a movement of goods are made where the movement starts. If the customer is VAT registered in the destination country, the supply will be exempt with credit, so there won't be any output tax. But it's still important to know which country the supply is made in to determine where the supply has to be recorded and what accounting requirements apply. So if we have a seller in France and a customer in Germany, and a supply of goods from one to the other involving the goods crossing the border, then the seller has made a supply in France, regardless of the contract terms, and will account for no output tax. The customer has made an acquisition in Germany, and will account for acquisition tax on the VAT return there. That's how it's supposed to work, but sometimes there can be complications. The 2007 case of IMAG Handel Eder concerned a chain of transactions in which two of the companies were in the same member state. It didn't qualify for the triangulation simplification, which requires three parties to be registered in three different states. Suppliers in Italy and in the Netherlands had a customer, K. They sold metal to K, but the goods were for the benefit of another company, E, which was the appellant in the case. So K made an onward supply to E. The problem that the Court of Justice had to consider arose from the fact that K and E were both in Austria, so the supply between them appeared to be a domestic Austrian supply, but the goods were delivered directly from the suppliers to E or to E's customers in Austria. K gave the instructions to freight forwarders to transport the goods, and the risk of loss during transit was K's. The Austrian authorities decided that K, which hadn't handled the goods, shouldn't have accounted for output tax, so E couldn't deduct the VAT charged by K as input tax. In effect, E had made an acquisition on arrival of the goods, and the acquisition VAT and input tax should net off on E's VAT return. The Court of Justice ruled that there can only be one intra-community dispatch in such a chain of supplies. The one which is exempted under Article 138 is the one which leads to the intra-community transport. The other is treated as made in the country where the goods arrive. In effect, the Court of Justice confirmed that K and E had treated these transactions correctly. The suppliers in Italy and the Netherlands had made a supply to K, which involved the transport of the goods, and it made no difference that K, their customer, organised that transport. Those supplies were made in Italy and in the Netherlands, and they were properly exempted in those countries. K must therefore have made the acquisition of the goods in Austria, and K made a domestic supply to E on which Austrian output tax was properly charged. If it was properly charged by K to E, then it was properly deducted by E. It's not clear why the Austrian authorities should take this point, unless K had disappeared with the output tax before paying it over. After all, if E had been denied input tax because VAT shouldn't have been charged, then K should have been entitled to a refund of the same amount, if K had paid the output tax over to the authorities already. So it seems likely that this was yet another variation on a missing trader fraud. The recent Société Fonderie case concerned a different problem, not a chain of supplies, but rather a chain of movements of the goods. It featured an Italian manufacturer which used subcontractors in other countries for a final application of paint to its products. So the goods were sent to a French subcontractor, but not as a sale. Rather, the French company supplied a service to the manufacturer. Before the VAT package was introduced in 2010 to change the place of business-to-business services, that was subject to French VAT. It was work on goods performed in France where the goods stayed in France afterwards. That was what the case was about. The Italian company made a claim for an 8th Directive refund of French VAT. The facts of the case predated the implementation of the electronic refund system in Directive 2008-9, and the French authorities refused to repay that claim. The goods had been ordered by a business customer in France, so the supply of the goods, in the sense only of delivery to the customer, happened after they had been painted in France. The French authorities refused the 8th Directive claim because they said this was a supply in France for VAT purposes as well as delivery, which meant that the only way to recover French VAT was for the Italian manufacturer to register in France, account for output tax on the supply, and claim input tax on the painting work. The Court of Justice agreed that goods could only be supplied when they conformed to the contract between the supplier and the customer. The transport of the unpainted goods from Italy to the French subcontractor couldn't therefore be part of the supply. The supply itself didn't involve a movement of goods between countries because the goods couldn't have been supplied before they were painted. Remember that triangulation is a simplification to avoid having to register in other member states for particular types of transaction, but it clearly doesn't apply here. Triangulation requires 2 supplies of goods and 3 parties registered in 3 different states. I'm not sure how common this particular diagram is, but it does seem to create a complication. Since the 1st of January 2010, the service of the subcontractor would in any case be reverse charged in Italy, which would remove the particular point of the case, but not the general principle. The subcontractor will no longer charge French VAT to the manufacturer, but the manufacturer is still making supplies of goods in France and ought therefore to be registered there. If it incurs any other French VAT, it wouldn't be able to make a direct electronic refund claim, but the liability for output tax is the more important obligation. Advocate General Cocotte noted in her opinion that this might interfere with the proper functioning of the internal market, because it could lead to suppliers favouring the use of subcontractors in their own country. However, it was logical and necessary in order to maintain safeguards against possible fraud involving intra-community supplies.